This judgment was actually 3 different cases heard together, all of which arose as a result of the outbreak of war between Great Britain and Germany in August 1914. This brief case note uses Porter and Freudenberg as its example. The outbreak of war had a number of consequences. For one thing, British companies were prohibited from doing business with German companies. Second, many German companies operating in Britain packed up and went home. And third, diplomatic relations between the two countries were cut off. Freudenberg were a company making mantles, a type of cloak. They had premises on Hanover Square in London, which they leased from Porter. On 28 September 1914, a few weeks after the outbreak of war, Freudenberg removed all the stock and fittings from the shop and returned the key to Porter via Freudenberg's agent Barnes. Porter sued for the outstanding rent. The immediate question, however, was how they could actually serve Freudenberg with the claim. The defendant was no longer in England, so ordinary personal service was not possible. Ordinarily, this would have merely been an inconvenience because there are arrangements between countries to facilitate the service of documents from one jurisdiction within the territory of another. But those arrangements had ended when diplomatic relations ended. They therefore went to court seeking an order for substituted service. The idea was that they would serve the writ on the agent Barnes, and that would be accepted by the court as good service. The Chief Justice, Lord Reading, said, "In order that substituted service may be permitted, it must be clearly shown that the plaintiff is in fact unable to effect personal service, and that the writ is likely to reach the defendant or come to his knowledge if the method of substituted service which is asked for by the plaintiff is adopted. The court may then make such order as may seem just." The terms of this rule are of very wide application and give a very wide discretion, which we are not inclined to limit. The court made the order allowing substituted service. The rules for substituted service today, found in Uniform Civil Procedure Rule 116, are essentially the same. The applicant must show why they are unable to effect personal service, and they must show that the proposed substituted form of service is likely to bring the claim to the attention of the defendant.